Resuming to continue our study of Bill S-228. Our second panel has arrived. We welcome Nathalie Loveman, Senior Counsel, Criminal Policy Division, and also Morna Boyle, Counsel, Criminal Law Policy Section. Welcome to you. Thank you for joining us. We'll begin with your opening remarks. We'll give you 5 to 7 minutes or so, and then we'll have questions from the senators. Please proceed.
Thank you. Thank you for the opportunity to be here today with you to discuss Bill S-228. I know that this committee has considered this issue previously and is very familiar with the changes proposed in this bill. We appreciate the opportunity to return to this committee, as we did when you considered former S-250, and we hope that our appearance today will assist you in your ongoing deliberations. On nous a demandé de partager quelques commentaires.
We've been asked to provide short opening remarks, and so we thought it would be useful to share with the committee our understanding of the effect of the proposed changes and how they align with existing criminal law.
So, as Senator Boyer has previously explained, Bill S-228 proposes to amend the Criminal Code to clarify that the law of assault applies to all coerced sterilization procedures. It would do this by specifying that a sterilization procedure constitutes a wounding or a maiming for the purposes of the aggravated assault offense provision in the Criminal Code. Aggravated assault is the most serious assault offense in criminal law, carrying a maximum penalty of 14 years imprisonment, and it applies where an assault wounds, maims, disfigures, or endangers the life of the victim. Le projet de loi définirait également.
The bill would also define sterilized procedure expansively to include any act that results in the permanent prevention of reproduction, regardless of whether the procedure is reversible through subsequent surgical procedure.
Including sterilization procedures involve wounding or maiming a patient. They already constitute aggravated assault if they are performed without valid consent. In this respect, Bill S-228 reflects the current state of the law by making clear that the provision is for greater certainty, which means that the amendments are intended to clarify the law, not change it. Cette approche permettrait donc de préciser.
This approach would therefore make it clear that established legal principles concerning assault would continue to apply to coerced sterilization procedures.
Are articulated in both the common law and Section 265 of the Criminal Code, which defines assault for the purposes of the Code's assault provisions. These principles also clarify that assault law does not apply where legally effective consent is provided. In particular, those principles stipulate that, number one, legally effective consent must be freely given or voluntary, which means there can be no fraud or duress. This principle is codified in subsection 265(3), which specifies that consent is not obtained in law where the complainant submits or does not resist by reason of violence or threat of violence, fraud, or the exercise of authority. 2, legally effective consent must go to the nature of the act, which requires that the patient have a foundation of knowledge. This has been described as knowledge of the purpose of the operation, knowledge of the events, or perception as to what is about to take place. And 3, legally effective consent must be given with the ability to understand, which means that patients must be able to appreciate the nature of an act. The Supreme Court of Canada has affirmed that medical procedures carried out without valid consent constitute assault, and that assault law will recognize consent to applications of force that have social value, such as appropriate surgical interventions. These principles are articulated in the Supreme Court's 1988 Morgenthaler decision and 1991 Jobidon decision, respectively. Merci encore de nous avoir donné l'occasion d'être.
Thank you again for the opportunity to be here with you today, and we'd welcome any questions that you may have. Thank you very much.
All right, thank you. We'll now move to questions. I'll allow the Deputy Chair, Senator Batters, followed by Senatrice Miville-Deschênes, Senator Prosper, Senator Boyer, Senator Simons.
Thank you very much. Appreciate that, Chair. All right. Thank you for that very good explanation of exactly what we're looking at here. And I just wanted to go back to something, and it was something that if there was time I was going to ask on the previous panel when this arose, but because there wasn't time for a second round, I decided that I would just kind of tailor it to bring up here. And really what I want to do is to just, particularly because there was a reference to this issue of coercion by Senator Simons when she was asking some questions, and she mentioned my name, and I wanted to clarify what I've actually said at this past committee about that issue directly. And so I'm looking back at the transcript from this committee of September 19th, 2024, when it was last discussed, and when we had some discussion about the bill as it currently stands. And so at that particular committee, Ms. Levman was actually giving her, as usual, very good testimony to help us understand these types of complex matters very well. And she was at this one point answering questions from Senator Boyer, and Ms. Levman said, "I would like to underscore that the proposed amendment in no way alters existing assault law. However, it does underscore that the law of assault continues to apply to all sterilization procedures, all of them, that are performed without the patient's legally effective consent." And then she said, and speaking again, she was to Senator Boyer, "Your amendment underscores that valid consent must be provided to all sterilization procedures, regardless of whether sterilization was the primary purpose, regardless of whether subsequent surgical intervention could reverse it. There is clarity there through the amendment that you have proposed." And then further, Ms. Levman went on to say, when Senator Boyer was asking her whether we should take the word coerced out of the existing motion we have before us today, because that had previously been in there, Ms. Levman said, "I am saying yes, that including the term coerced could be interpreted as requiring proof of something more than the absence of legally effective consent under assault law. That could make non-consensual sterilization procedures more difficult to prove than other forms of aggravated assault, which I understand is not at all the committee's intention or objective. That's why the concern was raised." And she further went on to say sterilization procedures, which of course are legitimate medical procedures that do have social value, provided that legally effective consent is provided. That is why the assault provisions are silent on consent in respect to legitimate medical procedures. This means that the assault law consent rules always apply to legitimate medical procedures, and that those procedures constitute assault where those rules are violated. And then a little bit after that, I asked Ms. Levman about this. I said, "I do agree about the need to take out the word coerced out of what is paragraph 268.1 sub 1 in this proposed amendment, because to say coerced sterilization procedure, I think could add another element that the prosecutor would have to prove in that case to say coerced. Then in paragraph 268.1 sub 2, the definition provided for sterilization procedure simply says sterilization procedure and then provides the definition rather than coerced sterilization procedure. Is that also part of your reasoning that you think it is problematic to include the word coerced?" And Ms. Levman responded, "I think the main concern about including the term coerced is that it looks like it adds another element to the offense that needs to be proved by the prosecutor." So I just wanted to include that because I think it's important for the public watching this to understand what the actual situation is dealing with the word coerced, and just wondered if you had anything to add to that that could add any further context, or does that kind of provide what you would need on that?
I will turn it over to my colleague. I believe it provides the main crux of the point.
Thank you for the opportunity to speak, Senator. I think what I would like to underscore for the committee is that the term coerced in this context is being used loosely as a label to describe what it is you're talking about. But what makes the procedure coerced in law is the violation of the assault consent rules. And they are both in Section 265 and in jurisprudence. So we mustn't forget the jurisprudential part. It's not just 265 and subsection 265(3). It's also jurisprudence, and I believe Senator Boyer was quite eloquent on that point. Thank you.
Senatrice Neuville-Deschênes.
Donc,
There were questions earlier. And do you hear the simultaneous interpretation? Yes, you do. Okay. Testing 1, 2, 3. This is the English channel. Testing, testing 1, 2, 3. This is the English channel. This is the English interpretation. Testing, testing, testing 1, 2, 3. This is the English channel. Good. My colleagues, including Senator Simon, asked questions earlier about any ramifications that might be adverse on obstetricians who practiced sterilisation. Now, my question for you is this. You've worked with Senator Boyer on these amendments. Did you consult broadly in the medical profession, including obstetricians, before you came forward with this proposed amendment? Did you get any assurance, or at the very least, have you had discussions with stakeholders, those who actually perform sterilisation, and sometimes for quite straightforward and legitimate reasons, if they are in fact wary of the legislation as it is currently drafted?
Thank you. Thank you for that question. So just to clarify, consistent with my testimony last time, we did provide support, but through our minister's office only. So what we did was consider the different viewpoints of the impacted parties, and one of the reasons why a for greater certainty clause was suggested is specifically because it wouldn't change the law. If it doesn't change the law, it can't have a chilling effect, and it can't impact medical practitioners either. Section 45 continues to operate the way it's always operated, and the aggravated assault provision continues to apply to all non-consensual surgical procedures, meaning surgical procedures that are performed without legally effective consent as per Section 265 and assault law jurisprudence.
très bien. Ceci dit, ma question était...
Well, thank you. But that said, my question was, has there been a consultative process? Have physicians been consulted? I understand what you said, that the legislation isn't changing, but sterilisation is now singled out in the legislation, and by virtue of that fact, that potentially might cause concerns within a profession. So my question was there any consultation before this proposal was put forward, i.e. with the medical profession?
No, we did not speak to people from the medical profession. We did speak informally with some nurses and midwives from Indigenous Services Canada. So we did get some informal perspectives from them, but there was no formal consultation, which is fairly normal for a private member's bill.
Senator Prosper.
Thank you, Chair, and thank you to the witnesses for being here and discussing this very important topic here. I just have a question, and it was noted within the previous panel and just now with respect to the consent provisions within the criminal code. I believe you referenced section 265, sub 3, which sort of gives the context for consent. And my question is, I guess, quite simple. Do you think that provision involving consent should stand and is sufficient when we take into consideration some of the factors that we have heard through the testimony involving sterilization, particularly as it relates to vulnerable and marginalized people. Do you think those provisions adequately meet those challenges that vulnerable and marginalized people face within the context of sterilization, I guess?
I believe the last time that I was here, I talked about the three underlying principles undergirding the concept of consent in assault law, which my colleague has already gone over. And I pointed to some examples that they would capture. So, for example, the first one is that consent must be freely given. What types of cases would that cover? Well, and I said that this rule is at issue where a patient is pressured or deceived into consenting to a medical procedure. And then the second one is that consent has to go to the nature of the act. And I pointed out that that rule was at issue when a patient isn't provided with sufficient information to understand the nature of the procedure to which they're consenting. And then the third principle, that consent has to be given with the ability to understand. And I pointed out that that rule is at issue when the patient is a child or has a cognitive impairment. I'd also point out that where a person isn't told, it's just performed and there's no consent at all, the assault provisions would operate there to say that legally effective consent was not given. My understanding from the testimony before you and from the extensive studies that Parliament has undertaken on this issue, that does capture what people have come forward so bravely to share with you.
Thank you.
Chair. So survivors have told us that consent was often sought at very inappropriate times, during labor, under medication, or under duress or intense pressure from authority figures. Can you speak to how the existing law of consent addresses those circumstances and why reinforcing it in the context of sterilization is so important?
Thank you for that question, Senator Boyer. I'm happy to start the answer and then turn it over to my colleague to complete it. So as I said in my opening remarks, for consent to be legally effective in the context of assault law, it must be freely given and voluntary. So there cannot be fraud or duress. Situations where women are pressured or fooled or in an otherwise vulnerable position and told by a person in authority that this is something that has to happen, an argument could be made in those cases that the consent given was not legally effective because it did not meet those criteria of freely given and void of duress. I could turn it over to my colleague if you would like to speak any further to that.
I would just point out that it can be very difficult to provide definitive answers in respect of general cases. Usually law is applied on a case-by-case basis, as you know, so we can't definitively say that in a particular set of circumstances consent would absolutely be not valid. What we can say, though, definitively is which rules are operable, and I think that's what my colleague has done in the sense that principles like duress, like fraud, and duress is a very well-developed principle in assault law. I'd like to stress that, and I think I pointed out to this for this committee last time that assault law is quite ancient, and you, Senator Boyer, has already pointed out the extensive jurisprudence that applies. All of that helps courts, prosecutors, police, etc., decide whether or not a charge is warranted, whether or not to pursue a prosecution, and then a court to find whether or not legally effective consent has been given. But I absolutely support what my colleague said, which is that those types of factors, when they are present, they compromise the meaningfulness of consent for the purposes of assault law. And these are the types of cases that you have heard, I know, and the assault law principles do operate in that space.
Okay, so under those circumstances, what happens if a woman signs the consent form and then she revokes it before surgery? Would that be valid? And they say, no, you can't revoke it. We're taking you into the operating room and doing that tubal ligation.
She's withdrawn her consent in a case like that, so there is no consent.
Thank you.
Senator Simons, Senator Pate, Senator Wells. Senator Simons.
Thank you very much, Mr. Chair. I mean, I laughed a little bit, Ms. Levin, when you said assault law is the oldest. It's because we've been assaulting each other for longer than we've been, you know, engaging in crypto fraud. It is the original sin. And I understand what you're saying, that there's a huge body of jurisprudence behind all of this, so that the courts, the prosecutors, the judge would understand in a way that a layperson would not what is the scope of what is assault. What concerns me is the more psychological chilling effect on physicians who are being told that a standard operation that they perform day in and day out is prima facie a crime unless they read up to Section 45. Right? So, I mean, it says, I mean, if you look at the plain text, it says all sterilizations are aggravated assaults. Right? In a way that we don't say all appendectomies without consent, all amputations without consent, all, you know, tonsillectomies without consent are assault, although they would be. They would all be assaults. So I'm concerned about the chilling implications for people who are seeking gynecological care, or you know, if they're men, seeking care that is encompassed by sterilization. My office has drafted a hypothetical amendment, just in case. And I want to lay it out to you, and you tell me if you think it would be actually valuable, or if it would just confuse things more. And this would be hypothetically to add to Section 268.11 for greater certainty, comma, but subject to Section 45, comma, a sterilization procedure, et cetera, et cetera, et cetera. I know that legally that's not necessary. But could it be socially or politically useful?
Thank you for the question. Maybe first I'd like to go to S-228 itself and point out that what it says is a sterilization procedure is an act that wounds or maims a person for the purposes of Section 268. It does not say a sterilization procedure is an aggravated assault. It says that it's a wounding or a maiming. You still have to prove assault. In order to prove assault, you must go to Section 265 and prove a non-consensual touching of some sort. So that operates in very, very similarly, in fact, to existing 268 subsection 3, where you see, for greater certainty in this section, wounds or maims includes to excise, infibulate, or mutilate the labia, etc.
Just that genital mutilation like that doesn't have any medical function. I mean, that's only done to oppress women, whereas these other things are done routinely all the time for people's health.
But that's why in subsection 4, the code says, for the purposes of this section and section 265, no consent to the excision, infibulation, or mutilation of the the labia, etc., is valid. So they've specifically said consent to excision, infibulation, or mutilation of female genitalia is not valid unless it falls within two narrow exceptions. S-228 has no provision like that, which means that consent is valid. If proper consent is given according to Section 265 and the common law, all of those principles are followed, the sterilization procedure will not be an aggravated assault any more than any other surgical procedure or medical procedure would be any form of assault. That's why there's no equivalent of subsection 4 in Bill S-228. And so to your question about adding subject to Section 45, I would just say that it's not necessary at all.
It's not necessary legally.
No, Section 45 is a valid defense. It exists in the defense, in the general defense part of the code, and it is available to any doctor or medical practitioner who provides medical services to someone who is incapable of consenting, usually in an emergency situation like they're unconscious, etc. That's usually where it operates.
Thank you.
Senator Pate.
Thank you. Thank you both for your work, and I've received some information from lawyers who are concerned that introducing the phrase permanent prevention of reproduction might inadvertently raise the evidentiary threshold for aggravated assault by requiring permanence, which is not otherwise necessary to establish maiming under the criminal code. I'm curious what your thoughts are on that, and while you're contemplating that, research from the Department of Justice has shown that laws, in particular criminal law and sentencing law, do not necessarily deter behavior, and that there is some suggestion that the identification of a law like this might encourage doctors to lawyer up, as you, for lack of a better term, and not necessarily change their behavior, and that education is needed. So I'm curious what steps the Department of Justice would be taking to provide education, public education, as well as specific education around this for lawyers and doctors and the like.
Maybe I'll start with your latter question since that was more recent. I agree that always when you develop new provisions in the code, that training is very important, and Senator Boyer referred to the Survivor Circle. I have had the great honor to meet with them in person, and I have heard about all of the wonderful work that they're doing, and certainly we are there to support them and will continue to do so going forward. This amendment may well serve as some kind of an anchor or hanger to place training initiatives on. So that's what I would say about your second question. Your first one, it was about the results in the permanent prevention of reproduction, and then it says regardless of whether the procedure is reversible through a subsequent surgical procedure. So that deals with the possibility that sometimes snipping fallopian tubes, for example, that it can be fixed. But snipping fallopian tubes involves going into a person's body, so it involves a wounding and serious damage to internal organs. So I don't think that the inclusion of permanent is a problem, particularly where you have this regardless of whether the procedure is reversible. In any event, like I've said, aggravated assault is really an offense of general application, and that may be one of the reasons why there isn't as much awareness around how the law applies in a medical context. And this just clarifies that sterilization procedures, regardless of whether they can be reversed, or constitute aggravated assault if legally effective consent is not provided. So I don't see a problem myself, unless I've misunderstood, Senator, your question.
Yeah, no, the question I think you've answered, but what they were saying was that the evidentiary threshold might actually be raised by this to a requirement of permanence in order for maiming to, and I can think of lots of examples where aggravated assault may result in very serious injury, but not necessarily permanent injury, and that was the suggestion. Would this possibly raise the threshold?
I don't think so, because when you're talking about a surgical procedure, you are talking about something that results in at least temporarily permanent. I mean, you'd have to go back for another surgery in order to correct it, and I think that the definition's quite clear. I understand from previous testimony that Senator Boyer did a lot of work and consultation on that definition, so maybe she wishes to speak to that.
And then the issue of, has there been any new research on deterrence since the Department of
Not that
Justice?
I'm aware of.
Okay,
Yeah.
thank you.
Senator Wells?
So I'm going to ask you to help me understand here something. So if this new section becomes law and prevents would this new section prevent coercive or forced sterilization on an intersex child? Or does section 26(8) sub 3 take precedence here? Is there a conflict of these clauses?
So maybe I should, for the committee's benefit, review the FGM provision and how it works with the exceptions, because I think maybe that's what might be tripping you up.
It's the exception, the specific exception in 28(3).
Right.
That would seem only to apply to what the language is used to, sexual disorders of development, which we commonly would call intersex conditions. So, by my reading, this would be the only group in society that could legally be sterilized without consent.
Okay. So one thing that I want to stress is that the female genital mutilation provision was designed to address a very particular form of violence against women. It didn't contemplate the issue that you're raising. So that's the first thing that I'm going to say. And I want to point out that in the female genital mutilation, what it says is that excising, infibulating, or mutilating female genitalia constitutes a wounding or a maiming for the purposes of the assault provisions. And then it says you can't consent to it except in two very limited places. One of them is surgical procedures that are legitimate, meaning generally what they would apply to are things like removing a cancerous growth from the labia, or perhaps repairing the damage that was done by the process of female genital mutilation in the first place. That would involve excision. Excision just means to cut. That's all it means. So we need to be mindful of the fact that most surgical operations do involve cutting. What this A does, 3A, is it says that the law will recognize a person's consent to a valid, legitimate medical procedure that involves excision to female genitalia. That's what this says. And so the question then becomes, what is a valid medical procedure to female genitalia? I've just given you two examples. And in terms of intersex children, I understand that there is some development in the medical world, and I would refer to them because they are the experts on this, but the pediatric urology people have said that generally these things should not be done. So the question is the validity of a procedure on an intersex child. And also what we're talking about here is labia, right? Only female genitalia.
Let me give you another example then that steers away from female genitalia. So what would happen in the case of a botched circumcision where the penis was removed and the child then had their gonads removed and was assigned a female gender? So we have a famous case of this, that's happened without the consent of the child or even the knowledge of the parents. This could be considered then a case of forced sterilization if there was no consent from the child, the parent, or the guardian. So in your reading here then, section 6283 would not be a defense because that deals with, we'll say, female genitalia.
Well, no, I'm just saying that the only time the law will recognize consent in the context of excisions of female labia are where it's a legitimate medical procedure. In the case that you just articulated for us, there was no valid consent given at all. So aside from the botched operation part, you have the no consent part, which means that it's an assault. But the botched operation part also implicates Section 216, which imposes a duty of reasonable care on medical practitioners and implicates the criminal negligence offenses as well. We've been focusing in the context of coerced sterilization on aggravated assault because that's what's operative there. But I want to underscore that there are duties in the code on the part of medical practitioners to take reasonable care when they operate and provide medical procedures. And when that duty is not fulfilled, there's a marked departure from what a reasonable physician would do in that context, the criminal negligence laws would also apply.
I guess, too, what we're getting at here is in the case of an intersex baby, right? No baby can give consent. And sometimes then there is, as has been, coercion by a physician to have the parents, agree to a surgery. Then as the child develops their gender identity and realizes, their anatomy does not match their identity, that causes this kind of distress, which is why, this particular section, as it applies to female genitalia, has been a concern to the intersex, community that it could be misused. And as you say, right, we're getting to perhaps an understanding, but nothing codified. And there's certainly some physicians who may disagree that, you should wait until the child is able to determine the surgeries, if any, that they would like to correspond with the gender they identify with. So, there's just some concern that maybe, the confusion. I'm hoping our conversation, I don't know if it muddies things further or clarifies further for individuals about, a misuse of a particular section of the code.
But I don't think the problem is with Section 268, sub 3. I think the issue is whether or not the criminal law should recognize the consent of someone other than the patient who's a child in a case like that, and that raises separate legal issues from what's in current subsections 268, 3, and 4.
Sure. I would also just then, I don't want to go down the rabbit hole too far here, but the word normal. What is normal? What does normal reproductive function and normal sexual appearance mean? And by default, by using the word normal, you're assuming there's abnormal. Is that abnormal, because it has a medical... It's preventing a medical necessary function, which is often the defense. This is a medically necessary surgery.
So my understanding from the record of the bill that enacted this provision is what they meant was normal, meaning normal female genitalia. So if there's a cancerous growth, for example, and you remove it, you're making it look normal. It would maybe perhaps not the best term now, and maybe perhaps another term would be used. It's now been almost like about 30 years since this was enacted. But, you know, and same with if you're repairing the damage that's done by female genital mutilation, what you're doing is trying to reestablish a normal appearance, meaning what normal labia, female labia would look like.
Thank you for bearing with me.
Thank you. Senator Clement?
I just want to follow up on that in a different way. You know, you answered one of the questions around assault being one of the most ancient type of criminal activities covered by the code, and so there would be a lot of ancient jurisprudence around how to interpret this. But Senator Wells raises, you know, emerging, more important, more different issues that we're now paying attention to. So do we have jurisprudence now that can help with, you know, addressing some of these issues and our growing awareness as a society that we've done wrong in terms of how we define things?
That's, do you want to?
Yeah, I'm happy to. So the jurisprudence on these issues it is limited in that an in-depth case law search found that there have been many cases where doctors have been found criminally liable for non-consensual acts performed on patients in the course of their duties. However, the jurisprudence to date largely, almost exclusively in fact, focuses on sexual assaults, so sexual acts performed on patients without their consent. So it is a separate issue. We did find very limited case law in which the law of assault simpliciter has applied to cases of assault, and basically it's in situations where the individual administers medical treatment without actually being a qualified medical practitioner. So the large majority is sexual assaults in this case law to date.
And that would be fraud, right? If you're holding out yourself as a medical professional and you're claiming a treatment's going to have a beneficial impact that it doesn't, and a person agrees to undergo that treatment, then that consent will not be recognized in law. And I guess one thing to add to what my colleague has said is this may be one of the purposes of an amendment like this is, you know, to encourage reporting of cases, make people feel heard, get people to feel confidence to come forward, which of course is what leads to eventually modern case law. Right. Yes.
That's super helpful, thank you. And I just want to make a pitch here for the fact that our criminal code has not been reviewed in over 50 years. And so we are woefully out of date, generally speaking. So anyway, thank you, Mr. Chair.
Thank you. Are there any other questions by senators? If not, then colleagues, please join me in thanking our witnesses for their participation and presence here today. Thank you very much. Thank you, senators. This